Okay, excellent. It looks like it works. So without further ado, I think there's nothing else and I can get started with today's session. So welcome everybody. It's a pleasure. Oh, sorry, go ahead. Did you want to say something?
Oh no, don't worry.
Okay, great. So I just want to start off by talking a little bit about what we're going to be discussing for today. So I'm going to talk to you a little bit about international institutions. Now, in particular, I'm going to talk a little bit about what these international institutions are aimed to do, the pros and cons of them, what some common features are. And of course, then I'll dive down and look a little bit more into this idea of how each individual international institution behaves. So a little bit of detail about what exactly these institutions govern as a few examples of how international organizations and institutions do indeed behave. If anyone has questions at any point, please feel free to interrupt or just send a message to the chat or raise your hand. I'm very happy to answer throughout. And of course, if anyone has any comments, you can also feel free to interrupt. For the most part, I planned this out to be a lecture, so it's not going to be as interactive, but if you do have anything that you want me to focus on, please do let me know as well. Excellent. So let's get started with this discussion. Now, one of the starting points for understanding international institutions is for us to think a little bit about international law, because unlike most countries, you don't have a legitimate authority who can use violence or some kind of criminal sanction in order to enforce the rules that you impose. International law is instead about power to some extent. These rules are established by any kind of organization or any kind of entity within that organization who has the ability to sway what that organization ought to do. Because to be frank, the only real way in which you can actually enforce any rules internationally is through sanctions or other harder measures that are imposed by actors like individual states or by the UN, or separately, there's not a harm, but you can be denied the benefit of being within an international organization. And so given those are the primary mechanisms by which international organizations are able to exert their power to be able to influence people, it also means that people who are at the head of these international organizations have a great deal of power. And for the most part, this is oftentimes decided by things like how much funding a country contributes or neoliberal Western consensus. So many of these institutions are oftentimes controlled by people who might not always have neutral incentives. They might not always have the best interests of all countries equally in mind. So it's interesting because international law is called law, but realistically speaking, it is based upon power. It's based upon a recognition that law is based upon compliance and recognition. If no one follows the law, if it's never enforced, then there's no such thing as law in any general sense. However, as I note that, I do want to point out that public international law being between countries rather than between companies, which is private international law. But public international law is oftentimes about trying to strive towards a law-like framework to govern international affairs. This is true in some institutions, not all of them. So as I just mentioned, some institutions are pretty liable to having a dominant party take control or have power. But in some institutions, they do indeed strive towards a legitimate governing process that is law-like. What does that look like? Well, if we think about international institutions like the World Trade Organization, they actually have a rule in the World Trade Organization that any decisions made in the organization have to be made by consensus. So that seems to suggest that all countries have an equal amount of power to some extent. Even if you're a smaller developing country, or whether or not you're France or Germany, you technically have the same say because there's a consensus that needs to be met in order for the World Trade Organization to really do anything. I will point out that supporting the status quo isn't always necessarily a great thing, though, because supporting the status quo means that you typically support a regressive system or one that hasn't progressed that far. So insofar as many of these institutions strive towards a more genuine legal-like community with more rules, accountability, and structures, it may also mean that there's a status quo bias in place. But if the comparative, the alternative, is something like Western states or illegitimate interest dominating, this is still preferable in my eyes. Now, the other thing that I'll mention about trying to create law-like frameworks is that you also want to create things like courts. And this means that you have institutions like investor-state dispute settlement mechanisms and tribunals and organizations like the World Trade Organization. Essentially, these organizations are meant to try and address concerns about trade policy between countries or trade policy between countries and companies. And the reason why it's so important for there to be this sort of law-like structure is because it helps to encourage faith and trust in the institution. If it's seen as unfair and biased, it's a lot more likely that people end up leaving. However, if it's seen as a legitimate institution, one that has clear rules that it follows and legitimate guidelines, then it's a lot more likely that countries stay within it. The other thing is that it's crucial for stability. It provides some predictable outcomes to any sort of litigation or any sort of disagreement between countries or the like. And that is obviously really important for countries to feel as if they can invest in one another. I don't feel comfortable investing in another country if I know that they might just end up arbitrarily screwing me over and not giving me terms or not paying me what they promised to pay me. So having things like court-like structures helps to promote commercial certainty. You're more willing to invest and do trade with other countries or companies if you know there's some kind of governance structure that will ensure that there are consistent rules which will be applied and that I can count upon. Now, the other thing that I want to mention here is in terms of justifications for international law. So this is just a brief description about how exactly international law works on a broad basis, but I want to think a little bit about the pros and cons of international law broadly speaking before I talk more specifically about some details on punishment, compliance, and sovereignty. So the most common critique that you're going to hear against most of these international institutions is that they deprive certain communities of sovereignty. So it means that certain countries aren't able to make their own decisions, their own rules, and basically decide on what their population wants. As strong as this argument may seem, I think there might be a couple of holes in the argument that comes out. One thing is binding yourself to a long-run commitment doesn't necessarily mean that you violated your sovereignty. If I signed a contract to work for a business for 2 years, just because I'm in that business for 2 years and I can't leave without getting some kind of punishment does not mean that my individual autonomy or my individual sovereignty has been violated. Rather, all it really seems to suggest is that I made a bad decision, but I signed up for it. I agreed to it. There are lots of examples in which you might think about this. Another good example is having a constitution for countries. In many ways, constitutions bind the sovereignty of the existing government. They aren't able to make decisions because they're bound to this overarching document that is very, very difficult to change, nearly impossible to change in many contexts. And yet at the same time, we still believe that this is a legitimate expression of sovereignty. We think that this is part of a commitment that a country bound itself to, and therefore there can be no real genuine complaint that they're still a part of it. At the same time, I do acknowledge that there might be a timeline issue here. Maybe the people in the 80s consented to this international organization. So through the 90s, through the 2000s as legitimate because the majority of the population still supported these international organizations. But there's a time lag. I mean, considering that some of these institutions like the Bretton Woods institutions, the IMF, the World Bank, given that those things were formed in the 1940s, it is very plausible that the people who are in support of it at the time are no longer alive. And so I don't think you can always extend that logic into infinity, because at some point the population changes and the original population that gave legitimate justification for you to enter into an international organization is a different one. You need to be able to cater to the modern population and adjust for what they want. Similarly, many people argue that we should have regular constitutional conventions. So times for us to re-examine the Constitution and determine whether or not it's legitimate, what changes we want to make, whether or not we like it. And that's a really, really interesting thing to bear in mind, because that seems to represent the idea that our consent as citizens, as people of a country, only extends so far. It can't extend past 80 years when we're no longer alive. It can only extend to the here and now, to people who are directly affected in the immediate timeline afterwards. So that's a little bit in terms of the classic sovereignty issue here. I will also mention the pros in favor of international law. So there are two things I just want to note here. One thing is that international law is designed to solve coordination problems or collective action problems. What do I mean by that? Well, there are certain circumstances where problems can only be addressed on a global scale. That's either because the problem is so significant, think about something like the Syrian refugee crisis a few years ago. Alternatively, it's because you need to have all countries working together for them to feel comfortable in imposing some sort of measure. So as a good example, think about something like environmental protections. Individual countries don't really want to impose environmental protections. And the reason why is pretty simple. They don't really stop the end of the world because one country doesn't really affect that much unless you're China or the US. And there are perceived economic harms to it. In fact, those are pretty certain economic harms. Companies will want to invest into countries with laxer regulations, who have worse conditions and therefore who promote really terrible environmental abuse. The good of something like a big organization is that it allows for all countries to have some rules that they can consistently follow and feel as if it's actually worth it to start cutting down on emissions because they know every other country will. Thus, there's no disadvantage to them in terms of investment, and it also makes it infinitely more plausible and likely that climate change can actually be stopped and the objectives of these international organizations can be met in the very first place. So in many circumstances, international institutions exist because they serve a unique role that cannot be serviced by any other organization or country. It helps to resolve those coordination problems. It brings everyone to the table, the negotiating table, to the bargaining table, and ensures that they have some way of enforcing that rule that has been created. Relating this back to the idea of sovereignty, some might even say that this disputes the idea of sovereignty, because there are certain actions that governments do want to engage in. Governments don't want the complete end of the environment. They don't want climate change to be completely disastrous. Rather, what the government wants is to have some kind of positive resolution to the problem. But it's only possible when you're part of these international organizations. So in some ways, people might argue that sovereignty is increased when you're part of international organizations. Because at the end of the day, sovereignty is really a reflection of power that you have to control your own affairs. But if you don't have the power to control the environment, then the only way you can seize that power is through an international organization where you can make collective agreements and collective decisions. In some ways, that might actually help advance the interests of your citizens and your country more. So that's the first big thing that I want to note in terms of the motivation behind many of these international institutions. Obviously, there's another idea, which is sometimes that you need to hold bad governments accountable. And so binding yourself to an institution ensures that you're going to follow those rules, even if you have a terrible leader. So let's say, for instance, you have a constitutional provision on things like debt, not taking out too much debt. Part of the reason why that exists is so that really terrible leaders who come afterwards, who are irresponsible, aren't able to make those bad decisions. So it's not to say that the government right now is terrible. I mean, if the government's agreeing to these conditions, they're probably good. But the government of now is binding the governments of the future so that those governments of the future aren't doing terrible, awful things. So that's the perspective that you need to keep in mind here. The final benefit that I want to note, and this is to certain international institutions, but not all of them, is creating a community of people who are like-minded. So if you think about it, the European Union is not just about a community of economic transaction. It's about promoting this idea of the European citizen, of building European unity. And I know that's ironic because it's called the European Union, but that really is what it's for. The very origination of it as the European community was actually designed to create peace in Europe. So after World War II, the European community was created as a way of ensuring that countries had close links to one another so they wouldn't engage in war. So the very purpose of it was unity in the first place. But recently, they've been going towards this idea of a shared European identity. So there's clauses in the European Union now that talk about European citizenship. The idea that you're a citizen of the European Union, not just a citizen of your own individual state. And of course, there are huge benefits to being in the European Union that resemble being in a federal state. So your ability to cross borders with absolutely no checks in the Schengen zone is a really good example of how that happens. As just a brief clarification, the Schengen zone is basically an area in Europe and specifically in the European Union where there are no border controls. So you can go anywhere you want. Free trade is extremely easy because obviously there are very few checks, et cetera, et cetera, et cetera. Now, the idea here is that certain international institutions are striving for more than just the practical benefits of being in an international institution or organization. Many of them are striving towards creating a common identity, a common European community, something of the sort. Not all organizations are like this. Think, for instance, about institutions like ASEAN, which have a much more hands-off approach and don't really care about the domestic decisions of most governments. But this is a prominent feature of many international organizations, but particularly the European Union as a whole. So that covers quite a few justifications and basics on public international law. I'm now going to talk a little bit about enforcement and all the different ways in which enforcement happens, how governments try to create compliance. But before doing so, I want to check if anyone has any questions about what I've discussed thus far. Okay, it looks like there aren't any questions, so I'm going to continue on then. So the next thing to talk about is this fundamental dilemma that I mentioned before, which is that public international law is fundamentally unenforceable in some ways. The reason why is because, as I mentioned before, it's all about power dynamics and power relationships. It's quite difficult to hold a country like the United States accountable. Very few people want to sanction the United States for poor behavior because they're such an important part of the global market. It's going to have a huge effect on the economies of countries who do sanction the United States. The thing to bear in mind here then is that all international institutions need to find a way of enforcement that is effective. And so we want to think a little bit about what these punishments look like and how exactly they're administered and why they work. So some of these punishments: sanctioning a country, sanctioning an individual, freezing an individual's assets, preventing the travel of someone, ordering the extradition of war criminals. These are all different mechanisms that are oftentimes used in order to punish individuals or states. Now, the crucial thing here is that obviously the European Union or the other international institutions need to be able to actually enforce things, right? So why is it that states choose to listen, especially the powerful states who are unlikely to be punished in a meaningful way? Well, here are a few different reasons why. First of all, there's political pressure internally on countries. For instance, if we think about human rights courts, like the European Court of Human Rights, it's very difficult for countries to be able to persuade their citizens that what they did was fine when it was literally dubbed a human rights violation. And many times, these human rights violations are against the population themselves. So it's very, very likely that there's some kind of political pressure internally to force these sorts of governments to accept any kinds of consequences. So as a good example, if you get a fine in the European Court of Human Rights, you're probably going to pay it, not because you necessarily have to, but oftentimes because you feel as if you ought to due to political pressure from your country. So that's one big reason why it is these international institutions still end up being effective. The second thing to point out is that there are diplomatic constraints. Refraining from these organizations may lead to many countries basically exercising negative diplomatic consequences on those who don't comply. So passionate Western countries, for instance, who really care about things like the European Court of Human Rights or the International Criminal Court may be less likely to engage with countries or less likely to form close relationships with countries if they don't match their values on human rights and other sorts of issues. Now, clearly, there are some circumstances where the West is willing to compromise on their values. Think about Saudi Arabia and the fact that the US still ends up trading with them and is a huge partner with them. But that's only in some circumstances. Obviously, that's because it's within the West's best interest. But for other circumstances where that isn't within the West's best interest to be allies with you because you don't necessarily have huge reserves of oil, then complying with the political morality of many of these international institutions is necessary to gain access to any kind of investment. Finally, many of these international institutions or courts grant corresponding rights to countries. So as an example, when we think about the European Court of Human Rights, it primarily hears cases where states interfere with their citizens' rights. However, if you're Turkey and if you're Cyprus and you've been invaded by Turkey, you actually can sue Turkey and get some compensation. So you might have an incentive as Cyprus to listen to the European Court of Human Rights when they tell you you've done a really terrible thing, you need to pay a fine, because they may anticipate that they need similar protection or similar compensation in the future. So that's the thing to bear in mind there. Now, of course, even within this context, there are still some issues of enforceability. So international institutions oftentimes add additional sorts of measures that help to make public international law more palatable, so that the laws which are being applied seem fairer and more legitimate, and therefore people are willing to comply in the very first place. Now, I'm going to be looking at the European Court of Human Rights as a prime example of this. It's not necessarily the classical institution because it is a court, but I think it has very good illustrations of how exactly some of these organizations operate to cater to the interests of countries. And of course, I've already told you about other organizations like the World Trade Organization that engage in a process of consensus whenever they make decisions, thus also helping developing or small economies. Now, let's talk a little bit about why it is you might end up having measures taken by the court to make it easier for countries to comply, or how it is that happens. So the first thing is the European Court of Human Rights has this concept of the margin of appreciation. What the margin of appreciation says is that within these kinds of decisions, where it's a little bit more subjective, where it's more difficult for us to say what is right or wrong, the country is assumed to be correct and they're given the sovereignty to choose whatever they want to do. So why do you have a margin of appreciation, and what does this look like? The first thing is, if there's lots of wide-scale agreement between member states that something is a right, it's more likely to be considered a right, and therefore a violation of it is more likely to then be prosecuted and then punished. Now, one of the really good examples here is on something like same-sex marriage. The European Court of Human Rights doesn't actually impose laws on same-sex marriage or say that it's a violation of human rights to deny same-sex marriage, because many countries in Europe still disagree with the concept. And therefore, because many of its member states disagree, they think, well, it's less likely that our viewpoint is absolutely correct. It's less likely that our viewpoint is the only one that matters. And of course, they might be just afraid of alienating many of these countries. They don't want these countries to leave because they strongly disagree with the exact provisions that the European Court of Human Rights has handed out. The next thing that we want to bear in mind here is that the margin of appreciation also depends on the severity of the rights infringement. So if it's a really fundamental and basic right, like the right to life, a government engages in a genocide and kills hundreds and hundreds of people, it is much more likely that the European Court of Human Rights is going to be skeptical of the claim that the government is innocent. And this is because there's obviously really, really terrible things happening. If the government just simply if the European Court of Human Rights simply allowed governments to get away with the worst abuses, like genocide, like murder, what is the point of that court in the first place? Maybe they get more compliance, but that compliance isn't worth very much if you're doing nothing in actuality. So that's another big consideration, how severe the rights infringement is, and that seems to be informed by this underlying concern or this underlying consideration that we clearly need to have some degree of efficacy and some degree of punishing really harsh crimes or terrible actions in order to get any kind of good. The last thing to bear in mind for the margin of appreciation, and this is quite an interesting one, the European Court of Human Rights also considers the amount of consideration a decision was granted. So if there's a lengthy and very detailed legislative discussion in the House of Commons about this law, it's much more likely that the European Court of Human Rights deliberates and says, okay, fine, you can make that decision. And the reasoning here seems to be, well, it seems a lot more likely that the decision was legitimate and valid if you've taken a long time to think about it. It's much more likely that you thought through the implications, you thought about what's best for yourself, what actually is going to help you. And those considerations make it substantially more likely that people end up buying it. So that's another big element here, the amount of consideration that decision was granted. Now, I talk about the European Court of Human Rights. Obviously, it also depends on the type of court. So in the context of the International Criminal Court, where these rights violations are obviously quite grave, jail time seems to be the only fair punishment. And so even though it might reduce actual compliance, the court only really offers jail time as a punishment because they don't want countries to get away with any of the abuses or the terrible things that happen. We could also see something like the European Court of Justice, who can be a little bit more expansive because they have wide sweeping powers. And the reason why is because they are part of the European Union. So if you don't want to be part of the European Court of Justice, good luck. You have to leave the EU and lose all the trade benefits and all of those other resulting goods. So because countries are a little bit more scared of having to leave the organization because the EU does a lot of useful things, grouping the court in guarantees some degree of compliance. So it's always important to think a little bit about exactly how we create compliance. Here we can see that compliance may be a little bit lower in grave circumstances, but it might be necessary so we can punish really horrible things. And of course, in contrast, oftentimes there's so many useful functions tied up in that court or related organizations and associations that countries are unlikely to leave. So that is on the European Court of Human Rights and how exactly that functions. Now, I want to move on to talk a little bit about some specific institutions and get some depth there so that we can understand what exactly they do. But before I move on to that section, I wanted to check if anyone has any questions about what we've discussed thus far. Okay, if not, the next topic of conversation is a little bit about international institutions and what exactly they do. So let me talk about a couple of them. Obviously, some of these institutions are going to be in slightly more depth than others. So if you have any questions, please do let me know. But at the same time, I don't know about every international institution. There are a couple that I have expertise on. And so those are the ones that I'm probably going to talk about in a little bit more depth. Let's start off by talking about the European Union. Now, the European Union obviously started out as an organization to try and promote peace, collaboration, and harmony amongst Europe after one of the most tragic and terrible times of war that have ever occurred in European history. However, it's become a much more expansive organization, and what it endeavors to cover and deal with is quite broad. So I'm going to talk a little bit about the structure of the European Court of Justice, and I'll talk about the kinds of laws it imposes, which of course are broadly more applicable to the European Union's charter and treaty, because the court only really enforces things in the treaty. So this is going to be a good illustration of how it is the European Court of Justice is a little bit more expansive and ends up overstepping in ways that the European Court of Human Rights does not. So let's jump into it and discuss this in a little bit of depth. So the European Court of Human Rights, the first thing that we want to bear in mind here is the architecture of the court. The European Court of not the European Court of Human Rights, I'm tired, the European Court of Justice. The European Court of Justice only has authority to rule on issues that are covered by the founding treaties of the European Union. So for instance, in the original treaties, primarily speaking, there were concerns about trade issues, and therefore the European Court of Justice only really legislated on trade issues for a very, very long time. As of late, the EU has become larger and more ambitious, so the treaties now include a wider variety of things, and therefore the court can intervene in a wider variety of things. But crucially, it has legitimacy because it can only intervene on things that states have already consented to allowing the European Union to govern. So that's the limitation of the jurisdiction of the European Court of Justice. Of course, this is all based on the fact of voluntary consent. So voluntary consent is important and it matters. That means that you can only really justify involvement on the things that countries voluntarily consented to, both on a principled level, but also on a practical level. Now, there are four big things I want to talk about in terms of European Court of Justice jurisprudence. So the decisions that they end up making and deciding. The first thing that I want to talk about is trade. So as you might imagine, the European Court of Justice and the European Union really cares about trade because that's one of its foundational building blocks. Now, what's really important to note here is that the ECJ prohibits anything that's considered a quantitative restriction on trade or measures equivalent to quantitative restrictions. So what does that mean? A quantitative restriction on trade is simply something like a quota. So there's a limit on the number of products that I can purchase from another country. And the problem with that is that it's discriminatory towards other countries' products, right? It means that it's much harder for Polish citizens to be able to sell goods in Germany because Germany is blocking those goods out from quotas. But of course, we also have measures equivalent to quantitative restrictions. So it stops things like tariffs. If a country increases tariffs on foreign goods, that has the functional effect of decreasing purchasing of those goods. And that unfortunately ends up meaning that you get really, really terrible outcomes because the free market isn't able to run its course. Or similarly, there are actually other legal decisions that are a little bit more expansive. So in the United Kingdom, at one point, the European Court of Justice deemed that it was illegal for them to close shops on Sunday for the day of rest because it limits access to the market from other countries. Now, of course, they ended up changing this decision because the reason why Britain chose that wasn't because they're trying to discriminate against foreign goods. In fact, it hurt British companies just as badly as it hurt foreign companies. Rather, they're doing it for their cultural values and their cultural perspectives. So that is an area in which you actually had some pretty wide sweeping European Court of Justice jurisprudence, but they've stepped back from that. After a case named Keck, it was decided that any selling arrangement, like how you advertise things, store hours when you're open, they can only be disallowed if they're discriminatory to foreign goods. So that rule about discrimination or that reasoning about discrimination to foreign goods became finalized in the European Court of Justice. However, there are some cases which seem to take this originally much more expansive set of rules. So for instance, there's a big case where basically in Sweden, they decided that a ban on water skis was illegal under European Court of Justice rules because it prevented foreign countries from selling water skis to Sweden, which is a little bit of a weird position overall. So ultimately, at the end of the day, they really protect trade. Exactly how much they protect trade is up to question. Obviously, they really care about anything that's explicit discrimination against their goods, but also they seem to sometimes intrude on things like domestic policy that has the inadvertent effect of limiting sales of those goods. The next thing to talk about is immigration and free movement in the European Union. So in the EU, the free movement of citizens is guaranteed. However, legal decisions have extended so that it also applies to family members of people who are European citizens or those who live in the European Union. So there's a case called Mary Carpenter. And in that case, it was determined that the deportation of a British citizen's Filipino wife would infringe on his right to free movement. And the logic here was very simple. This is because he traveled to other countries in the European Union in order to conduct trade. And he was only able to do that if his wife stayed at home to help raise their child. So because of this deportation, he can no longer engage in trade in other countries. And therefore, the European Court of Justice determined that in this scenario, there was actually a violation on his free movement, even though it was his wife who was being deported. So this is a really interesting case, and it shows how expansive the rules are. Of course, I personally think that this is a little bit of a stretch. I mean, I don't think it was intended to help cover the spouses of European citizens, but it's been used in that manner. It's been used effectively. There's only really one big exception on how wide-sweeping it is, which is family members who aren't job seekers do not get to receive welfare payments when they move to another European state, utilizing their right of European citizenship. So that is one exception because many people in the European Union don't support economic migrants who fail to work. The third thing that's really impressive about the European Court of Justice is its ability to have judicial intervention. So it's created a set of different legal norms which impose obligations onto individual member states and member countries. These are two in particular. First, the idea of direct effect, and second of all, the idea of Frankovich compensation. So on direct effect is a pretty lame term and it's complicated, but all it really refers to is the idea that courts and countries have to directly enforce the law of the European Union. So what does it normally look like when you're going through some kind of dispute settlement procedure? If you're in something like the World Trade Organization, it is the government who's taken to court, and once they're taken to court, they then have to voluntarily choose to pay a fine if they are indeed fined for their poor behavior. If a court is making this decision, though, in their own country, the court orders the government to do it. They order the government to comply with a certain rule, or else they're going to be punished. And this is really effective because it no longer relies on the European Union being able to enforce it upon the government. As long as that government has a functioning legal system that does indeed bind the government, direct effect means that local judiciaries, local courts are directly enforcing the law of the European Union and forcing the institution or the government to comply with it. So that's a really interesting thing. Most institutions do not require courts to actually rule on the basis of the institution's law domestically, but the European Union does. And that's a huge power it has, which is a big advantage. The second big thing is that in any single circumstance in which there was a severe violation of European Union law, there's huge compensation. So this just basically creates a binding legal obligation to enforce EU law and adds a lot of enforcement on top of direct effect. The final thing is I want to note that the court protects fundamental rights. So we're thinking about things like non-discrimination, the right to protest, democratic rights. But they've also been very good in protecting democratic rights and probably have been the most successful institution to do so. So there's a case called Commission in Poland in 2019. And in that case, the European Court of Justice ended up determining that government legislation, which would introduce a mandatory retirement age for judges, was illegal, because the point of the law was for the government to force a bunch of judges to retire so they could install and appoint their own judges who are more corrupt, who are serving the ruling party's interests. So the European Court of Justice has been useful at trying to preserve democracy, preserve justice systems, and ensure that countries are actually responsible. Now, there have been recent cases where Poland is basically trying to get away around that case, but it is really useful to know that the ECJ has endeavored to this. It has some measures which are designed to ensure that there's some degree of enforceability. As a whole, the ECJ really matters because it represents the European Union. This describes many of the treaty policies, like on free movement, but it also describes the enforcement method for many of these policies. And that's something that people oftentimes miss. They talk about the rules of the institution, but they don't think about how the rules are enforced and how they're upheld. And it makes it much harder for you to persuasively argue in a debate round that these rules are going to be listened to. So this is a really excellent example of how the European Union ensures those rules are listened to and packages it all together. So that's on the European Union. Does anyone have any particular questions on the European Union? If not, I'm going to briefly list some other kinds of economic unions that are useful to bear in mind. So we have the International Monetary Fund. This was formed by the Bretton Woods Conference in the 1940s, and the institution is designed to provide financial assistance and bailouts to countries who are struggling and in need. Now, one of the things about the International Monetary Fund is that voting power is dictated by how much money you contribute. That means that the US is the biggest voter in all of the IMF. And a bunch of other Western nations are pretty high up on that list, although China is too, because they're big contributors. Now, obviously, that's not ideal. It means that there might be a bit of a slant, and we can see lots of criticisms of the International Monetary Fund in the past. So for instance, there's a set of policies called structural adjustment policies that were implemented for a while. These were basically conditions for bailouts and loans for struggling countries. And the conditions were oftentimes incredibly harmful. So for instance, things like cutting healthcare spending or cutting education spending. Through these sorts of policies, people ended up dying because they had no access to the basic provision of goods and services. So the IMF has been criticized quite heavily for that. And they've even implemented austerity in places like Greece. So it might not even necessarily be that they're biased against developing countries. It might just be that there's a neoliberal consensus in terms of how they view they can deal with the problem. The issue is that economics has a lot of consensus by Chicago economists. And many of these institutions solidify that consensus because they become the dominant authority who makes all these decisions. But perhaps neoliberal trade policy is not always the best. Perhaps it isn't always effective. Perhaps this fundamental ideology is incorrect. Think about something like infant industry protection. So in the status quo, if you're part of an organization like the World Trade Organization, I'll talk about that in just a second, but if you're part of an institution like the World Trade Organization, wow, I just lost my train of thought, so I'll answer the question now and I'll get back to it. So how are laws made by the EU passed? It's passed through the European Parliament as well as the European Commission. The European Commission is basically made up of a bunch of different the European Council. It's made up of the heads of state of all these countries, and they can make a lot of decisions with their own accord. These are kind of more administrative decisions. The European Parliament also makes decisions. One of the terrible things about the European Parliament is that it's very low voter turnout. So like the voter turnout rate in many European Parliament elections is something like 8%, 9%, 10%. So it's not particularly democratic. It's not particularly accountable. So that's one of the big critiques actually of the European Union. There's this idea of a democratic deficit, that the European Union ended up in a position where they're functionally passing a bunch of policies, but citizens aren't very engaged because those elections feel so distant, so hard to understand on policies that they're not used to. So that's a really, really big concern. I'm really glad that you asked that question. So back on the neoliberal consensus. So unlike the World Trade Organization, I think that the big thing here is that in many of these institutions, like the IMF, they have this kind of fundamental belief. Oh yes, infant industry protection, that's what I was on. So there's a really general policy in the World Trade Organization or in international trade that you can't raise tariffs on other countries if you're part of the WTO. The reason why is because that discriminates against their goods. It makes it harder for them to sell their products in your country. But lots of countries actually successfully use tariffs as part of the development strategy. Think about South Korea or Japan, who both imposed very high tariffs at the beginning of their tech sector because they needed to make sure that domestic consumers bought those products. And then once those companies got richer, they're able to develop and become international global superpowers. Whereas if they're thrust into the international market and they were underdeveloped, they would have just been outcompeted from the very outset. They need to have a safe domestic market for themselves to grow in. And that was the only way they became successful. So perhaps some of the development models that neoliberal economists promote just aren't that helpful. With the World Bank, it's primarily focused on development aid, so providing aid to countries in order to assist them to continue to grow, develop, and become better. The thing that I will say about the World Bank here is that obviously it's kind of similar to the IMF. The structure of how voting works is very similar, and they oftentimes make decisions together. So not always the best. However, there have been some reforms. In 1996, they actually issued the Highly Indebted Poor Countries Initiative, where if countries undertook a few different kinds of measures to help make debt more sustainable, they'd have all their debt forgiven by the IMF and the World Bank. And this indeed actually did happen. So as of now, I believe 37 of 39 countries in the HIBC program have actually successfully fulfilled the conditions and have received full debt relief from the IMF and the World Bank. Now this leads into talking a little bit about the World Trade Organization. I think I gave an example of that in terms of neoliberalism, but the World Trade Organization kind of affects trade policy, also thinks a little bit about intellectual property laws, and settles disputes between countries when there are trade issues. One of the most distinctive things about the World Trade Organization is this idea of the most favored nations rule. The most favored nations rule means that you have to treat all countries equally. So if you lower tariffs for one country, you also have to lower tariffs for every other country to the same level. The only exception is if you're in a free trade agreement. Obviously, you can treat your partners in a free trade agreement favorably because that's the point of the free trade agreement. But if it's just a regular random country, you have to treat them the same as the best countries you treat, or as the countries you treat the best. So if you lower tariffs a lot for one country, that has to be true of all countries. They also offer things like technical advice, so advisors that help developing countries to continue to develop and grow. And obviously, as I mentioned, they have dispute settlement mechanisms that I went over at the very top. Now, the World Trade Organization isn't too much more interesting than that. The only other thing I'll talk about is IP law. So one big critique is on intellectual property law. Lots of people think that IP law is really terrible and restrictive, and that ends up limiting the developing world from accessing lots of IP. So things like pharmaceuticals that have patent protection on top of them. I think that this is quite a strong argument. And in fact, in many circumstances, countries have effectively done this. They've negotiated and bargained to effectively allow for themselves to create generic versions of the drug. So in South Africa and many parts of Africa during the HIV/AIDS epidemic at its crisis or its peak, they ended up deciding to start producing generic versions of antiretroviral drugs, basically medicines that help to deal with HIV/AIDS. At first, countries like the US were really angry, but they couldn't really do much. And eventually the international community realized how dire the problem was, and they ended up saying that it was fine for South Africa and other African nations to create generic versions of these drugs to distribute for cheap. So that's an example of where it's been successful. However, there are obviously some risks to it. If we look at countries like India, where they violate a law of patent law, companies like GlaxoSmithKline just kind of stop shipping them vaccines or other IP and stop producing there because they're afraid that they're going to just take those products and then produce generic versions of them. There are also ways to mitigate the problems with the intellectual property regime that already exists. So for instance, there's something called the Global Patents Pool Fund, which is where a lot of developing countries work together to negotiate a license. A license just being a government or a company saying, you can produce this good and you have to pay some amount for that legal right. And so when all countries are going together to negotiate for a license, it usually makes it easier because these companies are selling in bulk, they're making a lot of money. As per usual, when you sell in bulk, you usually sell for a bit cheaper to just guarantee the sale. It's usually worth it to have guaranteed revenue than slightly more revenue. But also, I think there's this bargaining power thing. When all developing countries are working together to try and access these patents, it's hard for big international companies to pit them against each other or try and create unfavorable terms where they have to compete against each other to give the best offer to the pharmaceutical companies to start off with. So that's a little bit on the World Trade Organization. Now, I realize I've been talking for a while now, so I want to check in. Does anyone have any questions about the European Union, the World Trade Organization, the IMF, or the World Bank? Basically, many of the big international economic institutions that govern the globe. So in an instance where EU Parliament has declared EU LGBTQI free zone, does it overrule individual EU countries that have legislations against it? So the problem is it would be challenged in court because the EU does not have competency over social justice issues like this. So they actually have no real power over this in particular. Now, in the Charter of Fundamental Rights and Freedoms, or I forget what it's exactly called, but the European Charter, they do have some more specific rights, but those rights are a little bit more limited. It's been a little bit harder to actually bring them into fore, and there isn't as much litigation or as much case precedent on it, so it's not clear exactly how it operates. So maybe they can, but it's a little bit skeptical, or I'm a little bit skeptical because their mandate might not stretch that far. However, if they did have that mandate, yes, it would overrule individual EU countries that have legislations against it. So as long as it's part of the treaty, the EU is able to bind individual countries. I'm just not sure if gay rights are actually within the treaty of the EU, might be more within the European Court of Human Rights, if anything. Any other questions about anything that I've talked about these institutions before I move on to talking a little bit about more human rights aspects? Okay. If not, I'm going to end off by talking a little bit about the European Court of Human Rights and then a little bit about the International Criminal Court. Now, the ICC stuff is pretty lengthy. We'll see how much we can get into it. So, European Court of Human Rights. The European Court of Human Rights is actually separate from the European Court of Justice. This is a common misconception. The European Court of Human Rights is formed by the Council of Europe, which is a separate organization altogether. Now, with the European Court of Human Rights, as you might imagine, their primary role is to deal with the protection of basic human rights. One thing that I will point out is that the European Court of Human Rights actually has less of a political slant, mostly because it needs to keep these countries in. And unlike the EU, there aren't very many things that they can offer as bargaining. So that's one really big thing to consider here. Now, there are a couple of issues that I want to consider. First of all, rights inflation. One problem with the European Court of Human Rights that many academics point out is that its specific job is to establish rights. And that means that it might start to be a little bit too expansive in creating rights. So let me give you an example. There's a case called Hatton and UK. And in that case, the court considered a right to sleep as part of an Article 8 right to private life. I'll talk about the pros and cons of the European single market in just a moment. But anyways, as I was mentioning before, this was a pretty weird justification. So your right to sleep is part of your Article 8 right to private life. I think most people would argue that a right to sleep doesn't seem straightforwardly like it is part of a right in general, of any kind of human right. However, this is because the court is really meant to be right strengthening, and this can lead to the risk of an over-inclusive definition. It may even be a little bit more extreme than this, right? So for instance, with free expression, well, pornography is a type of free expression, but clearly it's not the sort of right which free expression is meant to protect. So expanding rights may sometimes potentially lead to overprotection. Now, one good thing is the court typically concludes that the objectives of the state end up outweighing the infringement of the right. So in Hatton and UK, the specific litigation was about the construction of a new terminal at Heathrow Airport. And even though they determined the right to sleep as part of your right to private life, they ended up deciding that the public goal of trying to ensure that you had another airport terminal was more important than some individuals' right to private life and sleep, and therefore outweighed. Pros and cons of the European single market. Free trade is generally pretty good. I mean, I think that the argument here is on free trade in general. Free trade is good because it lowers prices for consumers. It means that people get the most efficient goods. It means that you're able to stop any kind of obstructions. But obviously the harm is it ends up leading to unemployment in certain areas. So that's like the classical free trade stuff. But there's also the dynamic of the free movement of labor. So workers can move around in the EU as well. Now, there are obviously some benefits to it. For instance, it means that you're likely to get to economic equilibriums in places where there's high amounts of unemployment. Those people can move to places where you need more jobs, where you need more employees. Also, there are benefits in terms of being able to move to a different place, have a better life, all of the sort. There are some concerns though, obviously. Brain drain is probably less of a concern just because brain drain already happens in the status quo. Countries already have an incentive to take in the best and brightest from countries. So under a visa system, you still get some degree of brain drain. But I think a lot of the opposition about the free movement of labor is just that people end up moving to places to try and access welfare. It's oftentimes strategic, ends up taking too many resources, ends up making it hard to predict or plan around who's coming into your country, past criminals, allowing your country to determine what their democratic values are, all the kind of stuff like that. How effective are the conditions set by IMF to developing countries when they want to take loans? I mean, it depends. A lot of the time, these economies still end up bankrupting or defaulting again. So Argentina has defaulted like 9 different times. Part of the problem might be that there are just no structural reforms being made, like the structural reforms in terms of debt and overspending aren't being sufficiently met. Some might say it's just because the conditions aren't really even that good and not that important, and social improvement matters more. So kind of depends on your assessment of it and your read on it. There are multiple interpretations of that. So continue along with the European Court of Human Rights. The next thing that I want to talk about is anti-discrimination law, where they have a lot of really, really interesting legislation. So one thing is the approach that the European Court of Human Rights takes to anti-discrimination law is very, very contextual. They look at things like the underlying motivations of the parties or broader societal issues to help determine whether or not there was discrimination. Here are a couple of different examples. There are some cases of police negligence of domestic abuse, where basically the police didn't effectively investigate or didn't jail a man who committed domestic violence against his wife. Now, here, the court was able to determine that this was not just an issue of a failure to protect a citizen, therefore violating their right to life. It was also a violation of anti-discrimination laws, because the fact that there was wide-standing practices of judicial discrimination against women, that was used as an inference to believe that the government in general and these particular police officers were negligent in not doing their job and were doing it on a discriminatory basis. Similarly, in cases involving education, this happened. So in some parts of Europe, there are basically classrooms made for students who had special needs, but coincidentally, only Roma people got put into those classrooms. The Roma being colloquially known as gypsies, so that's actually an offensive term for them, but they're basically an ethnic group that's nomadic in the European Union. And because it was basically only Roma students in that class, and there wasn't really that strong of a justification for why it was just Roma students, it was assumed that there was some degree of discrimination in this circumstance. So that's a really important thing to bear in mind here. There are some interesting ways that you can infer discrimination, and the European Court of Human Rights is pretty bold about it. Next, on freedom of expression, the big thing that I'll say is that the freedom of expression is also very, very contextual. So it gives very little credence to things like racism or hate speech, but because political dissent and criticism matters, it gives that a wide discretion. It means that you have like a lot of right to talk about whatever you want as long as it's a political dissent or criticism. This is mostly just to ensure that democracies still have competition and proper scrutiny on governments. One thing that I will say is that online platforms have a really high burden in the European Court of Human Rights. If people have like comments on your platform and those comments are defamatory or hateful, you actually have a legal liability as a company to take it down, or else you could be sued in the European Court of Human Rights. Final thing to bear in mind here are remedies. If a country does violate the European Court of Human Rights mandates, then that just simply leads to a fine. Okay, so that's on the first issue. Now let's talk a little bit about International Criminal Court. So first of all, we just want to get a clear sense of the ICC. And I think the ICC is really important because lots of people talk about it in debate rounds, and it's quite extensive. So what is the ICC? The International Criminal Court is basically an institution meant to deal with the most heinous violations of international law. So we're talking about war crimes, genocide, crimes against humanity, and recently added the crime of aggression. So invading a country or starting a war without any due cause. Now, in dealing with them, we're going to talk about three things. First of all, we're going to talk about what the ICC and its predecessors look like. Second of all, we'll talk about criticisms within the ICC. Third of all, we'll talk about potential alternatives. And finally, we'll talk about reforms. So the ICC and its predecessors. Before the ICC, the way that war crimes were dealt with was through international criminal tribunals. Basically, these were ad hoc tribunals, essentially created for each individual conflict. So as you can see, Yugoslavia had a bunch of war crimes in the 90s. And so the UN created an international criminal tribunal just for Yugoslavia. Same for Rwanda. However, due to the horrors of these genocides, the United Nations decided that they need to form a permanent court. And therefore, they established the International Criminal Court in 2002 after getting countries to sign something called the Rome Statute. Basically, just the treaty that governs and establishes the International Criminal Court. Now, there are a couple of key things I want to note about the ICC. First of all, it's a voluntary organization. So it relies on countries being a part of it in order to prosecute anything and have jurisdiction and the authority to prosecute in the first place. This is about whether or not they even have the legal right to prosecute, not just about whether or not they're effective in prosecuting. And here, this means that you end up having a big problem because countries such as the US, Israel, Russia, and China have all chosen not to be a part of the ICC. The one good thing, though, is that the court can prosecute crimes which are committed within member states or committed by member states or committed by citizens of member states. This is really, really intriguing because what it ends up meaning is that Afghanistan being part of the ICC means that you can investigate the US military's actions in Afghanistan because there's still jurisdiction there. It's also why the ICC has open investigations into Israel and Palestine. The second note, though, is that jurisdiction is not enough. You might be able to have jurisdiction to have a court case, but you still need to be able to extradite a criminal and get them physically into the court themselves. So one big problem is that many countries are unwilling to send in the war criminals. Think about South Sudan, where Omar al-Bashir has been actually indicted, but in practice, South Africa has refused to hand over Omar al-Bashir when he comes to visit, despite the fact that it violates the extradition orders in the ICC. So that's a secondary concern. Third thing, as I mentioned, the jurisdiction is over war crimes, genocides, crimes against humanity, crime of aggression. Basically, war crimes and crimes against humanity are when civilians are killed. The only difference is that crimes against humanity can happen in non-wartime. Also, war crimes can also focus on things like taking prisoners of war or other military-specific practices. Genocide is the elimination of particular groups altogether, so ethnic groups, religions, cultures. The crime of aggression is about invasion, including things like potentially funding terrorist groups. And also, one last thing that I'll note is that it seems as if the court now prioritizes and prosecutes environmental crimes. It doesn't do so directly, but in 2016, it started to prioritize cases which are caused by or also cause substantial environmental damage. So while they might be prosecuting one of the 4 crimes allowed in the treaty, they may be indirectly considering the environment as well. The fourth thing to point out is that the court prosecutes individuals. So the European Court of Human Rights fines states, the International Criminal Court attacks individuals and gives them jail sentences. The shortest sentences have been for under a year for more trivial instances of human rights abuses. Honestly, a lot of this is actually because of trial manipulation. But for the worst military generals who plan to execute such egregious offenses, sentences have been as long as 30 years. The fifth thing that I want to point out is that the court is regionally diverse. All judges must be citizens of member states, and importantly, there are 2 judges per country. So this helps to ensure a relative amount of diversity. Sixth of all, the court follows normal processes of due process. So make sure that it reads your rights to you, it respects your judicial rights, innocent until proven guilty, etc. Seventh of all, the last chief prosecutor of the court is actually a woman of color from Gambia. So a woman named Fatou Bensouda. I apologize for any pronunciation issues. I think this really mitigates the accusations of bias that have historically plagued the court, especially because in the last 5 years, they've actually started indicting criminals from outside of Africa. There used to be a really, really big perception that the ICC was very biased against Africa because all the indictments issued until about 2014 were against African war criminals. Now it's getting better and there's a little bit more inclusivity. The eighth thing to point out, and this is actually really important, the ICC operates under the principle of complementarity. So it only prosecutes cases if it believes that national courts are incapable or unwilling to do so. So they don't end up intervening or taking away the justice of locals. They only do so when they need to be able to have an international prosecution to complement what already exists. Ninth, victims have an opportunity to voice their opinions and provide victim impact statements still. So they can fly to the courtroom, they can talk about the issues, and it's very different from other international criminal tribunals, which didn't really have that option. Finally, victims can claim reparations. So if they've been harmed, they can ask for a direct fine payment to them, but this has only been granted one time ever. Now, I know I sped through that, but those are just a couple of the core characteristics of the ICC. I'll also just copy and paste them into the chat so it's a little bit easier to keep track of that. So let me just do that. Give me one moment. It's not copy and pasting. I will try and just put this as a reading material for you all later then. That should have all of these notes. So just give me one sec. Let me see if I can copy and paste again. Nope, I am not. That's okay. All right, let's talk about some problems with the ICC. So as I mentioned, the biggest problem is that the court has been accused of a Western bias. Many states have tried to leave. Burundi did leave in 2017. Gambia attempted to, but because of an election which led to a new regime, they chose not to. South Africa also attempted to. The South African courts ruled it was unconstitutional based on South African law. However, as I mentioned, in recent years, it has become a lot better at looking at other parts of the world. So they've opened up investigations on the US's conduct in Afghanistan. It's looked at Bangladesh and Myanmar, looks at Georgia, looks at Palestine and Israel, Iraq and the UK, Colombia, Guinea, the Philippines, Ukraine, and Venezuela. These are all the places where investigations have been opened up in the past few years. And so it's become a lot more diverse there. However, despite that, a secondary problem is non-compliance and withdrawal. Even if they're becoming more and more legitimate, lots of countries don't want to submit to the court because their leaders might potentially be indicted. So think about Kenya and Uhuru Kenyatta, who also has been indicted by the court. So maybe he just doesn't want to be a part of the court because he doesn't want to have to go to jail. And he says that the bias issue is the reason why, even though it's become less biased as of late. So it could just be a justification. Now, there are obviously some ways that we can work around the problem of people leaving. For instance, we've already expanded jurisdiction in such a way that even if countries attempt to leave, you can still punish them because if they invaded a country that's part of the ICC, they're still under that jurisdiction. There's also natural incentives for countries to be part of the ICC for the reputation, for the ability to receive justice for your own or victims of crime, all of those sorts of things. There are also political reasons why it's hard to leave. As I mentioned, it might look really bad if you try and leave something that's explicitly a human rights court. However, there is obviously some circumstances where you do get retaliation. So for instance, under the Trump regime, sanctions were placed on high-ranking International Criminal Court officials that specifically included things like asset freezes and visa restrictions because they want to investigate the US. The Biden administration has kind of taken a more positive return to Obama-era relationships with the ICC, but there is a problem of obstruction. The really big thing that I want to mention here, which is distinct from what we've talked about earlier, is just that the sentences can be very short, and this is a problem. So there's this guy named Jean-Pierre Bemba. He was convicted of 3 counts of war crimes and 2 counts for crimes against humanity for not preventing his soldiers from killing civilians. He only received 18 months in jail, and his accomplices received less than a year in jail. Now, this is a really useful factor for trying to criticize the court. However, it omits a key detail. In actuality, Bemba was acquitted of the war crimes and crimes against humanity on appeal, but the sentence he received was for witness tampering. So it actually isn't that bad, and this is a little bit of a disingenuous example. If anyone tries to bring it up, just mention it is a little bit silly. Now let's talk about some potential alternatives to the International Criminal Court. Now the ICC is how an individual gets to the ICC. So the biggest way is typically when you have an indictment. So let's say someone ends up traveling to the UK, and they're a wanted war criminal. The UK, once they enter into those borders, will then just ship them off to the Hague, the ICC. So that's the primary mechanism by which it happens. This is really, really effective for like war criminals who are on the run. Maybe less so for heads of state, but if you're like a war criminal, like like Charles Taylor or something, you enter into a country, you're trying to flee because you have no protection anywhere, and that country just extradites you, then you end up in the court. So that's the primary mechanism by which it happens. Potential alternatives to the ICC. Now, one big alternative has been truth and reconciliation commissions. They're bodies which assist in post-conflict transition, and rather than prosecuting offenders, they aim to reach peace and reconciliation through a process of inquiry. What does that mean? Well, they offer amnesty, an official pardon to people who have done terrible things, but in exchange, they get things like information access, apologies, and a chance for closure. So for instance, they might discover where a mass burial site is so that the family members of victims are able to finally see their family member's body, or information about how exactly the genocide happened, or what kinds of actions are like how the command structure worked. It also makes it easier transition in some ways because many people believe that TRCs make it more likely dictators are going to step down from power as they can't be personally prosecuted. And it is also less likely to trigger any political sensitivities or ethnic tensions from prosecutions, where there's a fear that perhaps it's seen as victor's justice. I will point out, though, that when the ICC assumes the role of prosecution, it probably makes it less bad because the ICC doesn't seem like it favors one ethnic group or one group over the other. Now, what exactly do TRCs look like and how do they operate? They usually have international mediators who ensure fairness. So for instance, in Sierra Leone's TRC, lawyers from around the world were commissioners. In South Africa's TRC, Archbishop Desmond Tutu, who's a global human rights leader, was the central commissioner. As such, they're typically perceived to be more fair or impartial than nearly any alternative. Because domestic prosecution looks like there might be political bias and opportunism, whereas ICC prosecutions have always been accused of bias. Are all the sentences ICC short? No. Sometimes you can be jailed for like 20 years for war crimes. It does not offer the death sentence though, but there are like 20-year sentences that sometimes are issued. Now, why is it that TRCs might be better? First of all, there's some arguments of efficacy. It means that it's really, really important for getting information. Like, you might not even have the bodies or the proof that there have been genocides, and you need to get information about where these burial sites are. The only way we really do so is through TRCs. Otherwise, there's an incentive to just hide and destroy the evidence, making that prosecution almost entirely impossible. Second of all, as an opposing argument to TRCs, though, victims often feel hurt and disrespected by the lack of prosecution. So in South Africa, a number of victims attempted to sue the South African government for using TRCs instead. It didn't work, but it does show the dissatisfaction that exists. The third thing that I wanted to mention here is that TRCs kind of interact oddly with the ICC. It's not really clear that TRCs are actually even recognized by the ICC, and prosecution may still occur. There's been no case law here, but because the TRCs aren't actually prosecuting, the principle of complementarity may kick in, and you as the ICC may need to end up prosecuting. This doesn't really engage with all the depth, but it does give you some of the basic core concepts here, and you can think a little bit about those ideas further when you're thinking about how you would argue these motions. Finally, I'm going to talk a little bit about how exactly you get reforms to the ICC and what reforms have been suggested. One idea is in terms of subject matter reforms. Basically, people try to argue that you need to create accountability for other things, like crimes against democracy or crimes against the environment. These are fundamental rights which people are owed. However, I think there's also some more interesting and complex analysis here. It's not just that these issues are important, but large multinational corporations oftentimes end up having a lot of influence in countries because the countries are dependent on those MNCs. They're either reliant on them economically or there's political influence from dictators. Now, in these kinds of circumstances, maybe it's only if the case that you have the ICC prosecuting that you can get any change. So there's another big idea of necessity. Lots of countries don't prosecute on the basis of the environment or democracy because there are incentives not to. Dictators don't want to give up their ability to be dictators. Large multinational corporations still want to keep on exploiting the developing world, the labor practices there, and the environment there. At the same time, then, the Rome Statute does serve a unique role in the international order, and maybe we can deal with democracy and the environment in other ways. So for instance, things like civil lawsuits or ICJ decisions, which can impose fines. On a principle level, the difference is just that these crimes are not universally bad. No, not everyone just agrees that the environmental crimes are so terrible. And what even counts as a democratic crime? Does gerrymandering in the US, where they unfairly create voting districts that favor certain parties, does that count as a democratic crime? So there's a lot of ambiguity here. People aren't sure whether or not this actually is an example of it. And even when it is, people aren't certain that this is necessarily even a good thing in the first place. Finally, there's some interesting stuff about why it's important to not have these reforms because countries might leave. So if China has a big democratic principle, well, actually China's not part of the ICC, so that's not a great example. But let's say an undemocratic country has crimes against democracy put in the ICC. They're definitely going to leave the ICC because they don't want to be indicted. They don't want to be in that jurisdiction. So it might remove the ICC's ability to do things like investigate or prosecute crimes, not just environmental crimes, but also things like crimes against humanity, war crimes, etc. Another big reform that's been suggested is in terms of regional versus international human rights courts. So instead of having an international human rights court, instead you have like the African Criminal Court or something of the like. Now, one of the big reasons why this would happen is because of bias. But as I mentioned, there's a lot of criticisms against that argument because as of late, there's been less bias. Here's another argument that you can still make here, though. One big thing is that African states right now don't really benefit from the ICC. They're shipping off a bunch of dictators to the ICC for the West because the West doesn't like them. But the West isn't really shipping off people that that Africa wants in there, right? They're not shipping off like the US government for invading Afghanistan or anything of the like. So it's not just an issue about jurisdiction, it's about extradition. There's no way that US soldiers are ever going to be able to get into the ICC because the US will shield them and protect them. They'll never send them there. So what it looks like is lots of countries in Africa are making huge sacrifices, doing things for the West, but receiving very little benefit in return. Whereas if there was an African criminal court, it's a lot more likely that these countries benefit each other, that a war criminal who conducted terrible, terrible operations in Sierra Leone, well, if they flee to some place like Tanzania, then the Tanzanian government will extradite them back to ICC, or I guess in this case, to the regional criminal court, and they get prosecuted. And they're willing to do so because if a Tanzanian war criminal ever escapes, they may escape into Sierra Leone, and Sierra Leone needs to extradite them to the African Criminal Court. Whereas if we look at something like the West, they don't offer really anything at all. Oftentimes they seem completely disconnected, like they're not really giving any benefit by being a part of the institution. So there might be an argument about why the African Criminal Court has a better track record or is more likely to have good conduct because all countries gain from it, so they want to comply. Of course, though, international human rights courts are oftentimes very useful because they have more teeth. So if you look at human rights courts in places like ASEAN or human rights charters, they have almost no enforcement power. Moreover, international human rights courts are probably more likely to be fair, as regional human rights courts will have more political bargaining and horse trading between close allies. So think South Africa and Sudan, where there's an allyship between the leaders of the two countries. This might be much worse when there are fewer countries enforcing rules, particularly as there are tighter diplomatic links. Finally, in some cases of conflicts that extend past continents, it might be ineffective. So if a war criminal travels all the way to Latin America, the African Criminal Court really doesn't have that much power in those circumstances. It might be better to have an internationalized system. All right, great. So that pretty much covers everything that I wanted to talk about for today's lecture on international institutions. There's still about half an hour left, but there's not much I have to add. So I'm happy to end it here, but I want to check if anyone has any questions. Okay, well, lovely. If there are no questions, I want to say thank you all for being a lovely audience, for asking such great questions. And I hope you, oh yeah, go ahead. Aziri?
Can you all hear me?
Yeah.
Okay, so I wanted to ask, you were talking about the European court that handles human rights. So France currently has an issue with Islamophobia. So is it possible for a citizen of France to take the government to court if it feels like they're being racial when it comes to religious biases through their policies? And also, I wanted to ask that since the ICC is not actually benefiting Africa as a region, if it is possible for them to create their own regional blocks, wouldn't it actually affect the level of diplomacy when it comes to engagement with the West? Because I think that doing those kind of favors, like doing those kind of sending the terrorists that the West don't like to actually over there for them to persecute, is the only way they can actually maintain that form of alienization with them by actually doing things that they like. Because when it comes to global power, they don't actually have that kind of strong both economically and when it comes to voicing out their views, they just get that kind of level of buying and acceptance if they keep doing this kind of favors. So to me, I feel like they are much safer if they could just send the terrorists to the West for them to prosecute them, and then be on the safer side where they do not get on the blacklist, where they get unnecessary sanctions by the US or other countries that may feel like they're supporting them because they could raise those kind of allegations. So that's just my view, and then also the first question I asked.
Yeah, sorry. So that second question, sorry, go ahead.
I was asking if I was audible, if you guys could hear me.
Yeah, so I was just going to say the second question was a little bit spottier. The audio quality is a little bit weaker there. So if you could type that one, that'd be great. But I could hear the first question, which is on France. So certainly, they could be eligible to be sued in the European Court of Human Rights. The only big condition here is that the state engage in the discrimination. So it can't just be that there's discrimination by the population. It has to be the state, the government itself who engage in discriminatory policies. And it has to, of course, be for an unjustifiable reason. If they have some justification, then it wouldn't be illegal. For that second question, if you just want to type it in the chat, I can answer it there. But while we're waiting for that, does anyone else have any other questions they want to ask? Okay, if not, I'll just wait for that question to be written in the chat. And once I get it, I'll answer it, and then we can end off for today.